Group UKIP.
Of the UKIP group, Neil Hamilton.
Since last Tuesday, I've had the advantage of reading the government's printed case in the Supreme Court case, which is being heard today. And apart from what it says at the beginning, that the result of the referendum to leave the EU should be respected, it completely ignores the fact that the British people, by majority, gave a government a mandate to trigger Article 50. And that mandate from the British people includes 26 of the 29 seats that Labour won in the election in May for this Assembly. Although fine words at the start of this case say that the referendum result should be respected, the rest of the government's case is an obstacle in the way of respecting that result.
Well, I am not a Supreme Court Justice, and he, thank the Lord, is not a lawyer. And so we'll have to wait and see whether his submissions are correct or whether those of the Welsh Government are correct.
Well, the First Minister is misinformed because I am a member of the bar, as is he.
Does he have a practicing certificate?
That's not the first time that the First Minister has displayed his ignorance in this chamber. In the last 10 years, the Parliament at Westminster,
Allow the member to be heard, please. I'd like to hear the question.
In the last 10 years, the Parliament at Westminster has passed two very important acts to restrict the government's powers in respect of the prerogative in relation to European Union legislation, the 2008 European Union Amendment Act and the 2011 European Union Act, which provides that in certain circumstances the government should not take any decisions without a resolution or an act of the House of Commons or an act of Parliament or a referendum. In none of those acts does it refer to Article 50. And therefore, the prerogative powers of the Crown were not intended to be restricted by Parliament in this respect. And the Welsh Government's attempt to frustrate the expressed wish of the British people in a referendum where 17.5 million people voted to leave the EU is absolutely disgraceful.
Before the First Minister answers, could I tell all Cabinet Secretaries, especially the one I'm looking at, that the First Minister does not need any support from the Cabinet bench, or I don't think he needs any support. First Minister.
Well, unless the member is registered as a practicing barrister, he's not a lawyer. I'm not, and nor is he. I've been in court since 2000, January 2000, but there we are. But he's making a case that he should make the Supreme Court, not to me, and we shall wait and see what the Supreme Court does. But I did notice that his former party leader, he of the misspelling of a constituency yesterday, of course, famously on TV, threatened to lead a march of 100,000 people to the Supreme Court yesterday. That didn't happen. And rightly so, because it's only right that judges should be able to make up their own minds without ridiculous pressure being applied on them by the media and by politicians. This is the most important constitutional case, as the Counsel General has put it to me, since Charles I, although hopefully without the same outcome for anybody involved. There are important issues here, not just a prerogative, but in terms of what this means for the Welsh and Scottish legislatures and for Northern Ireland, particularly there with the border issues there. And these are issues that must be resolved as a matter of law. This is not something that's going to stop the referendum result from happening. That clearly will happen, but it has to be done surely in a lawful way.
Yes, I entirely agree. But the Welsh Government has intervened in this Supreme Court case in order to attempt to frustrate the wishes of the British people as freely expressed in a referendum. Otherwise, there would be no point in intervening in the case in the first place, because the First Minister has said many times that Labour will respect the result of the referendum, and therefore Labour MPs will or ought not to be whipped to vote against triggering Article 50. Well, if Labour MPs are not to vote against Article 50, what on earth is the point of the case in the first place?
Well, I'm not actually the leader of the opposition at Westminster. The principle is this, that we have taken the view that there are issues regarding Article 50 that would affect the powers of this place. And as a result, it's hugely important, therefore, that the situation of the people of Wales and Scotland and Northern Ireland is examined so we know constitutionally what the process should be. We would not accept a situation where the prerogative would be used to reduce the powers of this Assembly. And that's why it's important that the Supreme Court actually examines these issues to make sure that what is done, but is done legally, surely. Brexit was not a vote about ignoring courts or the law. We were told it was about empowering the UK Parliament, except when it's inconvenient. Now, Let the Supreme Court do its work. Let it examine these issues in detail, and then we will have the answer that is needed before the process then moves on, as inevitably it will.